And then I have here TAS's presidents, Christine Wilder, and also co-counsel Jim Weiss.
Good morning. I'll take the appearances for the defendant.
Good morning, Your Honor. Ross Meyer on behalf of Brandi Ehnes-Wilder, defendant. And I also have Morgan Silva with me and our paralegal, Tammy Spears.
Good morning.
Good morning.
This is the time set for an evidentiary hearing on the plaintiff's application for a preliminary injunction. Is the plaintiff ready to proceed?
Yes, Your Honor.
Okay. And the defendant's ready to proceed?
Yes, Your Honor.
Okay. So I'll keep track of time and try to divide the time as equally as possible. Are we going to launch right into the evidence, or did you have an opening statement that you wanted to make?
I had an opening statement I'd like to make, Your Honor, and I realize that's burning daylight, in terms of my time. And so I'd like to make an opening statement.
Okay, you may proceed.
My time, please. Thank you. I have not been good at that. Your Honor, TAS comes before you today to help us renew its license so it can stay in business. A ruling in TAS's favor today will allow hundreds of employees to keep their jobs, and it's going to allow the TAS dispensary to continue to serve the people of Prescott Valley. The evidence supports each of the four elements of a preliminary injunction or a TRO, right, which everybody knows is substantial likelihood of success on the merits to start. TAS has a substantial likelihood of success on the merits because the evidence is going to show that the defendant agreed in a December 9, 2021 governance document. And there's a lot of documents flying around in the case, Your Honor. That's a focus I want to kind of dial in on. Everybody agrees that governance document allows the court to remove a director that jeopardizes TAS license. The document also says the president can remove somebody for cause. Document also says that the court can remove a director for breach of fiduciary duty. And, as the court well knows, a fiduciary duty is the duty of utmost loyalty. And jeopardizing the license is about as existential as you can get. We're in kind of a 2.0 situation. A gentleman named Johnny Furneaux was removed from TAS for deleting a bunch of emails, which threatened the license. This is more of an existential threat because the company ends if TAS loses its license. So you can't get any more jeopardy. Irreparable harm, Your Honor. A lot of people probably come before you and say, hey, my business is going to collapse if somebody does a non-compete or competes against us. This is quite clear irreparable harm. If TAS can't renew its license, its business ends. There was some, I think, lip service to there's no irreparable harm here. In the response, I think the evidence will show there's clear irreparable harm. Third element of the test for preliminary injunction is balance of the hardships. And the evidence is going to show there's going to be no hardship to the defendant by simply signing the attestation. It's a ministerial document. And that's an adjective. I try not to use them, but the evidence that you're going to see, the actual application itself, the actual regulations by which the department made the application is ministerial. You're also going to hear from the other side. They're going to say evidence is, we don't really know what's in the application. We don't know what we're going to be asked to sign. And the evidence is going to show there's two separate sources of information for the defendant to know what's in the application. You're going to see evidence that the defendant has admitted that she has open, full access to the department's portal where the application was completed by Christine Wilder. That's one separate piece of evidence. Then you're going to see separate evidence that what I did is I had my client do, just for belts and suspenders, I had my client go to the portal and I said, screenshot the application from the portal so that if counsel for defendant says, hey, Art, we don't know what's in the application. This is all a mystery to us. We can't sign because we don't know what's in there. And that's, by the way, that's kind of buried on page 22 of their response brief. I pointed that out in our response papers. But what I did is, and you're going to see it in the evidence, I sent a letter to Mr. Meyer and said, you know, your client has full access to the portal. Here's her email admitting it, right? But even if she didn't, here's a screenshot of the applications that are completed. Evidence of that, Your Honor. So when you hear, we don't know what we're signing, we don't know what's going on, we don't know about this entity, you'll be able to weigh the evidence in that regard. The fourth element of the TRO is the public interest. And in a lot of cases, it doesn't apply. I think it does apply in this case because it's a dual license and the people of Prescott Valley are served by medical marijuana card holders are served up in Prescott Valley and recreational users are served up in Prescott Valley. So I think it serves the public interest. And also, you know, in our cases, sometimes we get caught up in the papers, right? But there's like real people right now, you know, 9 to 5 workers working up in a dispensary that's a TAS licensed dispensary. Yavapai Cash and Carry runs it. They use TAS's license to run the dispensary. They operate the dispensary. But those aren't hypothetical people. They're like real people up there that are going to lose their job if this license goes away. Who knows what happens? Who knows how it gets replaced? But the court knows that those people are going to all lose their jobs. That just goes away right away. So all 4 elements meet the test to enter a preliminary injunction. And we're here asking for narrow relief, right? We can't, you know, you've probably got over 100 exhibits for you. There's no way we're going to have time to put them in. We're focused on getting the license renewed. Okay, that's what we want to do. We just wanted her to sign a ministerial attestation so TAS can continue. We're going to focus on that. There's a lot of ancillary issues that can get litigated later in the case about the propriety of removal, the lack of removal, what document applies to what. I think what I'm trying to do is cut through the weeds for you and ask for that narrow relief of either please order her to sign the attestation or remove her. And the removal has got to be obviously within the court's jurisdiction, but it could be on a temporary basis or a suspension, or if it was a combined trial, a permanent injunction removing her permanently under Rule 65. But the reason we're here is we tried with the department to find a way to get the license renewed. And the department's lawyer, very nice gentleman, Greg Falls, has said in correspondence we put in our papers that, Art, you've either got to have the defendant sign and agree to sign to get your license renewed, or we need a court order. And that's the school of hard knocks. That's the department. We don't resolve fights between directors, and we're not going to do that. So that's why we're here. Now, like I said, you have lots of paper before you, but the irony is the case isn't that complicated. And let me tell you what the evidence will show in that regard. So the evidence is going to show that TAS is a nonprofit. The defendant has admitted that multiple times. The Arizona regulations governing cannabis nonprofits require directors to sign those ministerial attestations. They don't require a bunch of financial documents. It used to be the case, and I don't need to give a history of the cannabis regulations, but it used to be the case before 2022. And then, and you'll see it as an exhibit, it's not required. It wasn't required in 2024. It's not required now. It used to be, you'll hear from Christine Wilder, that there were audits done of all the dispensaries' books, and YCC would pay for very, very expensive audits of the books, and then those would be provided to TAS, and then TAS would give that to the Arizona Department of Health Services. That's no longer required, and it's in the regulations. Exhibits 1 and 2 that are going to be entered into evidence are blank attestations. Those are the attestations from the department that are on the department's portal that just for belts and suspenders, I provided to Mr. Meyer and said, here's the attestation. You'll see in exhibits 1 and 2. These are ministerial questions, and I'll let you know, we'll talk about them, but it speaks for itself. Very simple document. The completed application is in Exhibit 31 that I sent to Mr. Meyer on June 24th. The attestations are in Exhibits 1 and 2, and they're also in Exhibit 36, which I sent to Mr. Meyer on July 6th. Now, I asked, you'll see in the papers, asked Mr. Meyer, you know, he's admitted, and you'll see this, and the defendants admitted. This is a quote, when the defendant signed in 2024 the attestation, we knew that the TAS was operating as a nonprofit. And you'll see in the papers, I asked him, okay, well, what did you rely on? And he said, I'll get back to you. Never got back to me. You still don't know. Maybe you'll hear today, right? So then we said, okay, we don't know what they're getting at. They're asking for a bunch of documents which have nothing to do with the ministerial attestation and information on the application. And so what we did for belts and suspenders again is we said, okay, let's confirm with the defendant that the YC, you know, TAS's dispensary operation is operating in accordance with nonprofit laws. And what you're going to see as an exhibit, Your Honor, is a letter, or excuse me, an email from a gentleman named Mr. McQuaid, who Christine Wilder asked for it, and he states he's a licensed CPA, and he's YCC's controller. YCC operates the TAS dispensary. And what you're going to see in that, he says that the dispensary is operating in accordance with GAAP principles and is operating in compliance with nonprofit laws. And the court will hear that pursuant to ARS 10-3830, that directors can rely on such statements from CPAs and controllers. It's in the law because we said the law's an ass, but this makes perfect sense because directors aren't auditors, directors aren't necessarily accountants or experts, right? So they can rely on people, and that law allows people to rely on. And by the way, it wasn't even requested by the defendant in 2024 when she signed the attestation. Right? Oh, belts and suspenders, we gave it to him. Didn't move the dial. It's a constantly moving target, and you'll see that the requests for documents change. They're all broad, but they continue to change, right? And the interesting thing about it, Your Honor, is when we talk about 2024, when she signed the ministerial attestation, and 2026, when she won't sign the ministerial attestation, you're going to hear of a seismic event that is the reason she didn't sign. It has nothing to do with TAS. I'll get to that in a second, but let me tell you what's the same about 2024 and 2026, right? So in 2024, TAS is a nonprofit. In 2026, TAS is a nonprofit. There's a related divorce case going on. And you're going to see an exhibit from Judge Williams in the divorce case. She found that there's no genuine issue of material fact that TAS is a nonprofit. The defendant admitted in deposition. And after reams of papers, the court ruled that on, I believe the date was November 20th, 2025, TAS is a nonprofit. Everybody agrees TAS is a nonprofit. The defendant herself wrote to the department, it's an exhibit, in March of 2026, TAS is a nonprofit. Everybody agrees, nothing's changed. TAS still holds a dual cannabis license to sell medical and recreational marijuana. That hasn't changed since 2024. TAS still contracts with a company called Yavapai Cash and Carry, I'll just call them YCC, to operate TAS's dispensary in Prescott Valley. And the interesting thing is, Your Honor, that contract has been in place since 2017, right? And it was amended in May of 2022, but nothing's changed. The same dispensary, YCC has been running the TAS dispensary since 2017. Nothing's changed. Christine Wilder, the president of TAS, she still provides oversight of TAS operations and licensing. She has for now 11 years, since 2015. It has not changed. So if nothing's changed with TAS, right? You got to be, I'm scratching my head when I took the case. Why won't she sign, right? If nothing's changed. And again, it's just, she claims to have a love for TAS, but nothing's changed with TAS, but she won't sign. So, you know, Mark Twain comment, you know, truth is stranger than fiction. Fiction has to make sense. Well, yeah, it's a good quip, but even real life usually makes sense. There's a reason behind everything, right? And the evidence is going to show that the thing that changed things occurred on February 21 of 2025. That's when the defendant filed a divorce petition. The defendant and Ms. Wilder were married, okay? So before February 21, 2025, no regulatory complaints by the defendant. Defendant signs the attestation. Things are going along, right? After, here's what happens, Your Honor. The evidence is going to show that since that day that the defendant has engaged in a course of conduct that doesn't relate in any way, shape, or form to TAS or protecting TAS's license. I'm a big fan of that book, Sapiens. I can't pronounce the guy's name, but I love the book. And he talks about the fictional corporation, the corpus, the body. That's where the name comes from. Huge fan of that, right? So what we're dealing with here is two people, but I represent the other person. It's called TAS, right? That's the president of TAS and representing TAS. But the corpus of TAS, the evidence will show that the defendant's actions have nothing to do with preserving and protecting that corpus. It all has to do with the divorce and getting money out of the divorce. Now, I don't begrudge anybody for making arguments and making claims in their divorce case. They're entitled to do that. And that's what's happened. In fact, there's a divorce trial on August 25th that will decide the situation between the two ladies here, right? That's fine. But what you're going to see is the defendant is not only not acting in TAS interest, but is using TAS as a ransom to try to extract money from that divorce. And let me give you the evidence, what the evidence is going to show. Since the divorce decree was filed, this defendant has filed complaints with the Arizona Attorney General, IRS, Animal Control, Game and Fish, Yavapai County Sheriff, El Mirage Police Department, Maricopa County Sheriff's Office, Arizona Department of Real Estate, IRS, FBI, we think, Arizona Development Services. That's not an exhaustive list. 4 bar complaints against Mr. Weiss. And when I say these things, I'm not making an ad hominem attack here. Right? I'm saying that evidence is going to lead to the inference that the defendant is not acting for TAS, but acting for herself. And when I say that, you're going to see 3 or 4 emails where the defendant expressly and impliedly conditions settlement on not filing additional regulatory complaints. And as the court knows, or probably does know, ARS 13-1804 prohibits that. You're going to even see an email where Christine Wilder, by the way, has an order of protection out against the defendant. And she's here today because it doesn't apply to courts. That order of protection was first entered ex parte, and then it was affirmed after a hearing, and the defendant was given due process to argue it should be lifted. You're going to see an email that the defendant conditions settlement on Ms. Wilder lifting that order of protection. Those are just samples of what's going on. Christine Wilder has been, because of what's going on, I don't think it's hyperbolic to say, watching herself. That order orders the defendant not to have any guns as well, right? And there's reasons for these things. So when Christine Wilder acts cautiously, the evidence will show why. But none of that has anything to do with TAS, although TAS is at ransom because these complaints relate to TAS. Game and Fish doesn't, obviously, but the other regulatory complaints is trying to extract a settlement. So, let's get to the refusal to sign the renewal attestation. Earlier this year, the defendant started making noise that she wasn't going to sign the renewal attestation. And she used kind of visceral language such as TikTok, as in a bomb's going to go off. She's made social media posts to the effect that, you know, the plot is if I don't win, no one wins. And you're going to see those as exhibits. So you can draw inferences from those. But again, these things are not being done in the best interest of TAS. They're being done to try to extract a settlement. Let's talk about the refusal to sign. I talked about TAS, you know, that nothing has changed. TAS is still a nonprofit as it was when she signed. Still holds a dual cannabis license. Bill contracts with YCC. YCC still makes monthly payments to a Christine Wilder entity. That's been happening since 2017. Christine Wilder has been getting money from her entity for oversight services since 2017. That was split with a gentleman named Johnny Furneaux until December 8, 2021, when Mr. Furneaux was removed by Dan Martin. And then I handled that appeal where it was affirmed that he was removed. And nothing's changed. The money has continued to go from YCC to Christine Wilder's entity. It hasn't changed. Was that way in 2024? Is that way in 2026? You may hear a lot of noise about Christine Wilder's entity, right? KWLH, or her other entity, Tab Accounting and Bookkeeping, right? That receives payments from YCC. Those entities were receiving money from YCC for oversight services. KWLH was providing the oversight services for years, right? And the attestation was signed by the defendant in 2024 under those very circumstances. You may hear a lot of irrelevant noise about what KWLH or Task Accounting and Bookkeeping does with the money. I mean, we could spend a day talking about what Christine Wilder does for animals, but we're not here to do that, right? The downstream use of those funds that are paid from YCC that were being paid when the defendant signed the attestation is of no import. The question is, why is she not signing? So knowing nothing has changed and engaging in this dialogue, I get hired in early June of 2026. And what I start to do is I try to work with Mr. Meyer, and we didn't really have discussions. I just would send him emails. Here's information. Here's the application. Here's how it's completed. Here's the attestation forms. These are all available on the portal. Please have to sign. Okay, that's not good enough. Here's a statement from YCC, CPA, and controller. And it's never good enough, Your Honor. And again, nothing has changed. You may hear evidence impugning Christine Wilder, or you may hear.
Let me just interrupt you and interject. I'm a little bit concerned about how much time we're using for opening statement. You're going on half an hour.
Yeah.
And you have 100 exhibits marked between the parties, and I want to be able to consider the evidence and make a ruling. We're going to run out of time. So you can use your time as you see fit. I'm just giving you a heads up.
Yeah, I appreciate it, Your Honor. Let me conclude then, and thank you again. That's a habit I have not broken in 34 years. I appreciate it. In conclusion, each of the four elements of the evidence is going to show each of the four elements is met, Your Honor, and we would ask the court to enter the proposed order that we've given you. But in any event, help us find a path to get it, the past license renewed.
Okay, thank you, Mr. Bork. Mr. Meyer, do you wish to make an opening statement?
Yes, Your Honor. Good morning, Your Honor. Thank you for setting this hearing. I want to run through the four factors really quickly, but first I want to indicate that there's a lot of problems with the exhibits that have been thrown before you. There's a ton of issues since I've come into this case, and it's one that I don't think we could solve this in a day. I mean, whenever this case and the counterclaims we filed go to trial, this is going to take a long time to sort through the years of what's happened, what the evidence is, and what it said. And so that brings me to the issues that are before you today. And what we're trying to figure out is, number one, is Ms. Ehnes-Wilder required to sign an attestation that the entity is operating as a nonprofit currently? And the two questions are, is she currently a director or was she removed? And then separately, is there enough evidence that the court can compel her to sign this attestation? And on the merits, there's no way that it's clear as to what the operative documents are. We say that the December 9th, 2021 board documents in the morning are the operative documents. They say there's December 8th, there's December 9th, there's later documents. It's very confusing. We've spent a lot of time to go through and figure out how all of this worked. And some of our exhibits will show that the December 8th documents were created after the fact, were created on December 13th, 2021. And what that means is the December 9th documents that were completed then are the operative documents. You can't afterwards come back and say, oh, well, we meant to do this on December 8th. And the reason that's important is it gets to what this for cause and how a director is removed. And the reason there can't be a determination that Ms. Ehnes-Wilder was removed, aside from trying to figure out what the plaintiff is saying, I mean, they've said three things to this court already: that she was removed in writing in March of 2023. That's in paragraph 17 of the verified complaint. But then she was removed in 2024. And then she's removed in February 2025. And then you'll see throughout that Ms. Ehnes-Wilder was still acting as a director after the 2023 date and up until she was kicked out of her home and left essentially homeless on February 10th, 2024, or 25, I'm sorry. And that's what you're going to see. You're going to see that Ms. Wilder was the accuser, the judge, and the jury to make some determination that Ms. Ehnes-Wilder, we don't know what she did. What it says, and this is all that it says, is she breached a fiduciary duty. That's misspelled. And then also that theft. That's what we know of the accusation in the board documents and the meeting minutes. That's not sufficient for one person to act as the judge, jury, and accuser. Instead, what the bylaws say is they can come to court and have a judge or a jury make that determination. And that we say they've waived anything previously to remove her as a director because they have now come to court to get that determination made. So the point being is they can't even win on the merits today. Okay. Secondly, on signing the attestation, it's irrelevant as to why Ms. Ehnes-Wilder signed a form in 2024. The answer is very clear, that she was operating the entity. She knew it was operating as a nonprofit at that point. That makes sense. She was involved in the day-to-day. Then in February 2025, she's completely kicked out improperly. And that's what our counterclaim and lawsuit goes to. Secondly, she has indicated that she will sign the attestation. She wants to. She doesn't want the license to go away. She has indicated she will. However, she needs to either see the finances, and Ms. Wilder will not turn those over. I don't know why she won't turn them over. She's making an attestation to the department that it's operating as a nonprofit. There's going to be a lawsuit. There is one. We're going to get those in discovery to determine if that's correct. But it's unconscionable that Ms. Ehnes-Wilder was raising this issue in January of 2026, saying, hey, we're going to have this issue come up. Can you get me the finances so that I can confirm that it's still operating as a nonprofit? And it's a complete wall. They will not turn over the financial documents ever. They do not want to do that. So we also proposed, well, then have the CPA sign an attestation that the finances are correct and that it's operating as a nonprofit. They wouldn't do that either. They don't want to touch this. And the reason is because they're lying about it. And you'll hear Ms. Ehnes-Wilder talk about what she's concerned and the things that may have changed where it might not be operating as a nonprofit. And that's concerning. And the reason we know she doesn't want to turn over, Ms. Wilder doesn't want to turn over this information is because Judge Martin, in a May 23rd, 2017 minute entry, said defendant Christine Wilder's claim of authority under the final with corrections amended nonprofit bylaws of Total Accountability Systems 1, Inc., the plaintiff here, is invalid. And as plaintiff Johnny Furneaux did not sign that document, the weight of the evidence supports the finding that defendant Christine Wilder forged plaintiff Johnny.
To it, Your Honor, it's irrelevant, it's prejudicial. No
I don't need an objection during opening statement. He's telling me what he thinks the evidence is going to show. So proceed.
Thank you, Your Honor.
Forged plaintiff Johnny Furneaux's signature onto that document and altered her own signature so as to make the document appear a distinct and presumptively valid set of bylaws. That's the same thing going on here. You have 20 to 30 different sets of bylaws sent at different times, made at different times. We have the emails showing the actual times they were sent and what Ms. Wilder said at those points, and you're going to see that evidence. But it's concerning that Daniel Martin made a finding that she forged the same bylaw documents that now are being presented to you related to the same company, not the forged documents, but the same company, same issues, and we're back here again. And she only won that case because it was a discovery sanction against the other party. It was not a ruling on the merits that she was the sole director. It's not even something that can be used collaterally. And then the other part you'll see is they claim that there's 100 employees. And that's in declarations from the plaintiff. There's 100 employees of YCC, of the management company that's running it. They'll say Taz doesn't get any revenue. They'll say Taz doesn't have any employees. That's what they say in the divorce case to make sure that Ms. Ehnes-Wilder doesn't get any money. They're behind on paying her spousal support. They're trying to act like the shack that she lives in. It was $8,000. It doesn't even have a complete floor. She is living in poverty. And on the other side, they're making $200,000 of profit per month that's going into her account. And she has been completely shut off. She is scrambling because she's up against high-powered attorneys on the other side that have all the money in the world, and they're going up against her in a shack. She can't even get her health care paid to get surgery on her eye that she needs. And that's what's going through. And so she wants her day in court to be able to present this evidence, and she will absolutely sign the attestation, but she needs to know that it is operating as a nonprofit, and she can't swear to that because she's not given the finances. They won't present an affidavit of a CPA who's looked at the finances, and she can't make that attestation. And to say that it's not required isn't true, because if you look at R9-17-308 and you look at B, in their reply, they conspicuously left off B. And I think that's important because it absolutely indicates that they must. Here's what's required. A says, and this is 2A, an attestation in a department provided format that the dispensary is operating on a not-for-profit basis. Okay, that's the attestation form that you're going to see. Fine. And so they have an alternative, and that's why a TRO isn't proper here, is because they have an alternative. Brandi brought it up in January of this year, so they could have gone the alternative route. B says both of the following: a copy of an annual financial statement for the previous 2 years, or for the portion of the previous 2 years the dispensary was operational, prepared according to generally accepted accounting principles, and a report of an audit by an independent certified public accountant of the annual financial statement required in subsection 2BI, which I just read. So there are financial components to it. And the point of it is that the department wants to know that this entity is operating as a nonprofit. And Brandi is not able to do that if she's not able to look at the finances, or if she doesn't have this information. They will not provide that. In addition, you heard it during the opening that Ms. Ehnes-Wilder absolutely has access to the portal and has access to everything. What they leave out, they didn't tell you, is Ms. Wilder is able to view everything that she submits in the portal. Brandi is not able to view the applications that Christine submits. They're blocked off, and I've sent those screenshots to the plaintiff's attorneys. She can view the stuff that she submits, and she can go in, but she can't access the application. Just last night, the first time, I think they sent us one or both of I think just one of the applications. They sent us one. I've been asking for that since our return hearing, and they've said, no, you either have access. I've sent them videos showing, no, we don't. Look. And I get no response to indicate that I'm not responding to stuff. Maybe I've missed something, but I ran a report earlier this week, and between the two councils over there, there's 50 unresponded questions that I've sent to them. And I don't know how to get responses. We'll go through discovery and I'll get those answers. I don't mean to use today as a fishing expedition, because I think it's clear. They can't prevail on the merits, or at least it's a big time question and it's not clear. Public interest, they don't even have the 100 employees they say. I mean, I could make an argument that there might be a public interest, but not to order someone to untruthfully
But if the license isn't renewed, whether they're TAS's employees or YCC's employees, are there 100 employees of somebody that are about to lose their job if the dispensary shuts down?
That is correct. Of YCC and are employed through the license. That is correct. But to say they're TAS employees is incorrect and a misnomer. The irreparable harm, yes, it's there, but and losing the license, yes, that I've argued on other TROs that were rejected that, yeah, that's an irreparable harm. I agree. The problem is it's not irreparable because, well, I guess it is irreparable, but there's other alternatives and they just don't want to take them. And that brings up the true concern is we've been kicked out since February 2025, blocked from having access. We don't know what's in that application. We don't know how it's been operating, what changes have been made. We're not going to swear under oath that it has been operating as a nonprofit. And that brings me to my final point is I don't know how the court could make a determination and say, yes, I am confident that this nonprofit plaintiff has been operating as a nonprofit for the past 2 years. All you have is testimony from one witness that it has, but that's someone who's forged documents related to the same company before the court. You don't have finances. You don't have a CPA testifying here today. You don't have an expert. I don't know how anyone could make that determination on this record that they've been operating as a nonprofit. And that's the problem. Now, what Brandi has told the plaintiffs is, look, we'll submit this stipulation to the court if you give us one of these affidavits from the CPA that it is operating as a nonprofit, and then the court can order us to sign the attestation. Completely ignored that. On one phone call with plaintiff's counsel, they denied, they rejected that offer. I tried to follow up and put that in writing, and I was told, no, we didn't reject it. That's for Mr. Bork to respond. I've sent 2 emails since that phone conversation and no response from Mr. Bork. The point is, we want this license to renew, but we cannot verify that our attestation that it's been running as a nonprofit for the past 2 years would be accurate. And we're worried that there could be something in the application admitting that we're not a director. I don't know if that's in there. That wouldn't be true. Or that there is information in the finances that it's not operating as a nonprofit, and we're worried of signing a false affidavit.
Okay, thank you.
Your Honor.
The plaintiff may call its first witness. And before we
Yeah, thank you.
get to the first witness, I see we have somebody in the back of the courtroom, and I don't know if she's going to be a witness. Has the rule of exclusion been invoked?
Thank you, Your Honor. We would like to invoke the rule. We only have, I don't know who that is.
Is she a witness?
She is not a witness, Your
Okay,
Honor. And,
thank you.
Your Honor, we have one additional witness who is going to be testifying, I believe, this afternoon over Zoom or Teams.
Okay. Mr. Bork, the plaintiff may call its first witness.
Yes, call the defendant.
Okay. Ms. Ehnes-Wilder, would you come up here right in front of the clerk, please?
Starts at 27 is 1. Oh, 37. Okay.
No, right up here in front of the clerk, please. She's going to take your information and swear you in.
Seven task document. Okay. Yep. Okay. Because they put they don't remove the proceedings, they just started it. Your book is right now. Use the blue.
No, yeah, thanks.
Go ahead and have a seat over here. May proceed whenever you're ready, Mr. Bork.
Thank you, Your Honor. Ma'am, please refer to Exhibit 37.
And when you refer to the exhibit numbers, if you could identify whether it's plaintiffs or defendants, because you both started at 1. So
Thank you, Your Honor. Yeah, and unfortunately, I did start at 1, but I didn't realize 1 just became a higher number because there were exhibits in there, but that's life in the big city, so I'll deal with that. Ma'am, do you see Exhibit 37?
Yes.
And
this
that's
is plaintiffs 37?
yes,
Thank you.
yeah, sorry. Yes, do you see Plaintiffs Exhibit 37?
Yes.
And that's a December 9th, 2021 Board of Directors of TAS Amendment to Bylaws meeting. Do you see that?
Yes.
On the second page, is that your signature?
I mean, it is, I'm just not, I mean, I'm pretty sure that's the one that I hand signed. Yes.
Okay. And did you agree in signing this document, Plaintiffs Exhibit 37, did you agree to the terms in that document?
I don't, can you scroll it down a little bit?
Yes. Did you read this document before you signed it, Plaintiffs Exhibit 37?
I'm just trying to figure out if it's an actual exhibit I signed or not. I'm just trying to make sure that it's all correct because there's so many different ones going around. And all I know is the ones that I had that were all together in one
Ma'am,
document.
I'm sorry, ma'am. I've got limited time. Are you now, I thought you originally said you signed exhibit, that's your signature on 37. Are you saying it may not be your signature on 37?
I'm saying I don't know if it's the actual one that I signed or not. I don't know.
Okay. Did you sign a document with this language in it that's in Plaintiffs Exhibit 37?
I don't know.
Okay. Do you know if you ever signed a document that would allow the court to remove you as a director if you jeopardize TAS license?
I believe that was part of a document that I did sign, but I don't know that this is the document.
Okay, so you signed a document which has words in it that a director could be removed for jeopardizing TAS's license, correct?
It just changed what the definition of cause was.
Ma'am, That's not my question. My question is, do you remember signing a document that says that the court can remove you if you jeopardize TAS's license?
I don't remember.
Have you ever seen the document that's Plaintiff's Exhibit 37?
I mean, obviously I've seen it recently, but I don't know if this is equivalent to the original document.
So the answer is you have seen this document recently, correct?
Yes.
The last page of Exhibit 37 is an action meeting of the Board of Directors of Total Accountability Systems. Do you see that document?
Yes.
Is that your signature on that document?
Yes, I believe this one is I think this is the one that I signed. This looks right. I mean,
Okay.
no, no, I think I'm incorrect.
Ma'am, do you have any memory problems that you know of?
No, sir.
Now let's look at, and so that's the third page of Exhibit 37, Plaintiff's Exhibit 37. Just let's get clear on this. Did you, is that your signature or not on the third page of Plaintiff's Exhibit 37?
Well, I know it's my signature, but I don't know if I signed this because a lot of things were electronically signed and I didn't do a lot of electronic signatures, especially on those dates. We did
I'm
hand
just
sign.
talking about this document, ma'am. Is that your signature on page 3 of Plaintiff's Exhibit 37?
I mean, it is my signature. I just don't know if I'm the one that put it there.
Have you alleged that Christine Wilder forged your signature on this document?
I'm not alleging that anyone specifically forged a signature on a document.
I've never seen an allegation throughout this entire matter that you've alleged that Christine Wilder forged your signature. Are you alleging that today?
I mean, I can't say who would have done it.
Listen to my question, ma'am. I've never seen an allegation. I've read all the divorce papers. I've read the papers in this case. I've never seen an allegation by you that Christine Wilder has forged your signature. Are you alleging that she's forged your signature at some point?
There's a handful of documents that I know I did not sign that have my signature on them. So if you want to say that the inference is that she did it, I don't know if she had somebody else do it.
Okay,
No.
let's focus on Plaintiff's Exhibit 37. Are you alleging that Christine Wilder forged your signature?
Objection misstates testimony.
I don't know.
Overruled.
You don't know. So you've gone from, you think you signed Plaintiff's Exhibit 37 to, you don't even know if it's your signature and you're speculating that Christine Wilder possibly forged your signature on Plaintiff's Exhibit 37?
Well, I just don't know because this looks like an e-signature and not a handwritten signature.
Have you looked at your lawyer's own pleadings in this case regarding the December 9th document?
Yes, I mean, there's a couple of December 9th documents though. Some are authentic and some are not.
And so you don't know whether Plaintiff's Exhibit 37 is authentic or not? Is that what you're
I
saying?
can't tell by this signature because of the way that it looks on the screen. If I was to be able to see it on a piece of paper, I might be able to
Okay.
identify it better.
So have you ever signed a document that indicates that the court can remove you for jeopardizing TAS's license?
The document that I signed would have only said that it changed what cause was.
Ma'am, listen to my question. Have you ever signed a document that says that the court can remove a director for jeopardizing the TAS license?
Without having my documents in front of me, I don't remember what was in every single one of them off the top of my head.
I didn't ask you what's in every single one of them off the top of your head. I just want to focus on my question. Do you ever remember signing a document that indicates that the court can remove a TAS director for jeopardizing the TAS license? Say yes or no.
With as many years ago as it was, I don't recall.
And you've read your lawyer's papers that he's filed with the court, and those weren't many years ago, right? Those were weeks ago, correct?
Correct.
And do you remember him submitting papers to the court indicating that you signed a December 9, 2021 document
Yes.
that states that the court could remove a director that jeopardizes task license?
I'm pretty sure I do remember that, actually, because there's a lot of things. I have a couple of legal cases going on, so I'm sorry that there's
Ma'am,
just,
I don't care about your other legal cases. I've got limited time. So now are you saying you do remember that you signed a document that the court could remove you if you jeopardize task license?
I think it could be either director could be removed if they jeopardize the license, yes. Not just me.
Okay, but that includes you, correct?
Yes, either director.
And plaintiff's exhibit 37 indicates that the president shall be empowered to speak, to act, speak for, or otherwise represent tasks always and for all matters. You agreed to that, did you not, by signing?
What part is that in? Can you scroll to that
It's
section?
in the middle of page 1 on plaintiff's exhibit 37.
Yes, I think that looks correct. I mean, that section of it.
And you signed a document that states that, correct?
I'm pretty sure, yes.
Okay. And that document also, plaintiff's exhibit 37, states the president can remove any director or principal officer for cause. Do you see that?
That's the thing is I remember the other part that, like, that anyone can be removed, but I don't remember the president being, having the ability to
Are you
remove
saying
anybody
that
for
you
cause.
haven't seen this document that's plaintiff's exhibit 37? You haven't seen those words in any document? Ma'am?
I'm-
Have you seen those words in any document?
I have seen them in documents, but I don't know if they're the accurate document.
So you don't even know if you signed a document with those words that I just quoted
In 2021,
at any time?
I can't recall off the top of my head. All I know is by looking at the actual documents that are true and correct.
Okay. So you don't know whether you signed a document which contains those words. Okay, let's go on to the next one.
Objection, Misty.
Plaintiff's exhibit 37 states.
I'll strike the comment because it wasn't a question and ask your next question.
Thank you, Your Honor. Plaintiff's exhibit 37 on page 1 towards the bottom says the president has full authority to execute in the name of TAS all contracts and other documents on behalf of TAS. Do you see that?
Where is it at? Oh, I see it. I see it. Yes.
Okay. You agreed to that by signing a document dated December 9th, 2021, which has these words in it, correct?
I'll be honest, I don't know for a fact because I don't know if this is the authentic document.
No, I said by signing a document. Are you saying you've never signed a document ever, to your recollection, that says the president has full authority to execute in the name of TAS all contracts and other documents on behalf of TAS?
No, I don't recall that.
You testified in a deposition in June of 2025 that TAS is a nonprofit, correct?
I have a
Objection,
question.
Foundation.
I have a question. Am I able to see this in a paper copy? Like, can I see this in an actual sheet of paper instead of on a screen?
Let me ask you this. Do you recall taking a position with the divorce court in 2025 that TAS is a nonprofit?
Objection, Foundation.
Overruled.
Yes, TAS is a nonprofit. That's how it's filed with the ACC.
And TAS held a dual cannabis license to sell medical and recreational marijuana when you signed the 2024 attestation, correct?
Correct.
And at the time in 2024, TAS contracted with a company called Yavapai Cash and Carry for Yavapai Cash and Carry to operate TAS's dispensary in Prescott Valley, correct? Is
Yes.
that a yes?
Yes.
And at the time you signed the 2024 attestation, Yavapai Cash and Carry made monthly payments to a Christine Wilder entity, correct?
Objection foundation.
Overruled. She can testify if she knows that.
All payments were made to tax accounting and bookkeeping.
Who's the owner of TAS Accounting and Bookkeeping?
Well, Christy is the only one that's on it.
Christine Wilder is the only member of that LLC, correct?
Correct. It was created during our marriage and
That wasn't, strike.
Ask your next question.
Thank you, Your Honor. So Christine Wilder is the only owner of TAS Accounting and Bookkeeping LLC, correct?
yes,
And you've never been an owner, correct?
no,
And you've never been an officer?
No.
So when you signed the 2024 attestation, you knew that Yavapai Cash and Carry was operating the TAS dispensary, and you knew that Yavapai Cash and Carry was making monthly payments to a Christine Wilder entity, correct?
yes,
And you knew in the divorce case, did you not, that in the summer of 2025, YCC began making payments to a separate Christine Wilder entity called KWLH, correct?
I'm sorry, when was that?
In November of 2025, you knew that things had changed and YCC was now making payments to a different Christine Wilder entity by the name of KWLH, correct?
I don't know if I ever knew by an actual date, no, but I know that a 1099 got issued to KWLH for 2024 while all the money was going into tax accounting and bookkeeping. I don't know
Well,
when it
yeah.
got changed.
Okay. In any event, what's your knowledge now in terms of where the payments are going from Yavapai Cash and Carry?
I have no idea.
Now, when you signed the attestation, you knew that YCC money was going to a Christine Wilder entity. You established that, correct?
Correct.
Do you have any evidence that YCC is operating the dispensary?
I don't have any evidence of them operating illegally or legally.
Did your attorney provide you with the statement in an email on June 24th that I provided him from the Yavapai Cash and Carry CPA, Mr. McQuaid?
Yes.
And did you read it?
I think I talked to him a little bit about it, but I don't know if I like read the whole thing in its entirety. If you wanted to bring it up, I can look at it.
Let's go to Exhibit 64.
This is plaintiff 60.
Plaintiff's Exhibit 64. Thank you, Your Honor. You see Exhibit 64, ma'am?
Yes,
And you received that from your attorney on or about June 24th, 2026?
yes,
Move to admit plaintiff's Exhibit 64, Your Honor.
Any objection?
No, no objection.
Plaintiff 64 is received.
Now, I didn't see that you filed any regulatory complaints against Tass or Christine Wilder before February 21, 2025, when you filed your divorce petition. Do I have that right?
yeah, I think that's correct.
And then after that date, you've filed complaints with the Arizona Attorney General, correct?
Yes,
IRS,
yes,
Animal Control,
no,
Game and Fish,
yes,
Yavapai County Sheriff.
yes.
Do you claim in this case that you worked for either the Christine Wilder entities or TAS?
I've never been employed.
Is the answer you don't claim you've ever worked for KWLH, TAB, or TAS?
No, I was involved in TAS in all the operations. I was also involved in a lot of operations at KWLH, but I was not employed.
You submitted an affidavit on the day you filed your divorce that you hadn't worked since 2011, correct?
Correct.
Is that truthful?
Your Honor.
I made a mistake on that. I had 1 year that I did collect income.
Okay.
Your Honor, just so we make sure we get a record, is the microphone picking this up?
I'll be notified by my staff if it's not picking up.
Okay.
So
So you signed a AFI affidavit of financial information on February 21, 2025, under penalty of perjury that you had not worked since 2011, correct?
Where did I write since 2011? Okay, I see where the previous job was listed. Yes.
2009, 66.
And honestly, the employment that I had,
Ma'am, my only question was, did you sign that
I'm-
document under
yes.
penalty of perjury?
I did, and it was incorrect. I didn't realize that until recently.
Let's go to Exhibit 66.
I'm sorry, can you scroll back to where that 2011 was?
Yeah, on plaintiff's Exhibit 66, I'm going to break myself of this habit. I see on page, and that was from my memory, and I think it was right, on page 3 of plaintiff's Exhibit 66, if you go down about 3/4 of the way, it says date previous job ended 1/10/2011.
Right, okay.
Were you truthful in that statement on your AFI?
I had forgotten about a year that I had worked, so that was incorrect.
Okay, what was incorrect about it?
The last year that I worked was 2017 or 16, I forget. I printed out all my IRS transcripts and
I don't care about the print of the transcripts. I want to know what's incorrect about you stating on a AFI under penalty of perjury that the last date you worked was 2011.
the reason I misstated it is
Not the reason. How was it in error?
it's an error.
You worked after that, if you did.
It is an error because I was working for many years unpaid, and one of the years in between there, I got paid. So I forgot about the paid year.
What was the paid year?
I believe it was 2016.
Okay. Other than that, is Exhibit 66, correct?
Yes.
Plaintiff's Exhibit 66. Move to admit Plaintiff's Exhibit 66.
Any objection?
Yes, Your Honor, we have an objection. This was disclosed to us late last night, along with about 50 other exhibits that were submitted.
We've been exchanged. We just got exhibits from them yesterday, Your Honor. In addition, they've had this in the domestic relations case. It's been disclosed.
The objection's overruled. Plaintiff 66 is received.
Do you have any reason to believe that an entity other than a Christine Wilder entity is receiving payments from YCC?
The management services agreement says that TAS should be receiving the money, so I don't know.
I didn't ask that. I asked, do you have any reason to believe that an entity other than Christine Wilder's entity is receiving YCC money?
I mean, it's possible. I
Do you have any evidence that that's happening?
know.
Know what it was in the original thing? Was it 42?
It's Exhibit 45. Let's look at Plaintiff's Exhibit 45, please. Do you see that Yavapai County Sheriff's Office document?
Yes.
And did you report certain complaints to the Yavapai County Sheriff's Office on or about April 4th, 2025 and after?
I did.
Were you truthful?
Yes.
Have you reviewed this report in Exhibit 44?
I have.
45.
Thanks, Your Honor. Plaintiff's Exhibit 45. You have?
I'm sorry, what was the question?
Have you reviewed Exhibit 45?
Not thoroughly. I only received it last night.
Are you saying you didn't receive it in the divorce case?
No.
March.
So you received it last night. Did you read it?
I breezed over it. Yeah, I kind of skimmed it because it was really late.
Okay. Did you see anything in there that was inaccurate about what the sheriff said you told the sheriff?
I don't think so. If there's any inaccuracies, they're not off by much. I don't think there's anything that and everything in here I knew to be true at that time, or I thought to be true.
And you told the sheriff that if you could get Ms. Wilder out of TAS, then you could get to the TAS money, did you not?
No.
You didn't say that to the
No.
sheriff? You didn't say that to the sheriff that if you could get her on a criminal count, like fraud or forgery, you could get her out and then start getting money again?
You want to show me where it says that?
I'm just asking you.
No, I don't remember saying that.
Sheriff.
No, I do not
That's
remember saying that.
what you would tell the sheriff.
Not that I wanted to get her removed so I can get all the money, no.
Move to admit Plaintiff's Exhibit 45.
Any objection?
Yes, Your Honor, hearsay, no foundation, no evidence, a witness to speak to its truth.
How is this not hearsay, Mr. Bork? How is this not hearsay?
I can put Mr. Weiss on the stand to, just for the purpose of indicating how he obtained it?
Well, being a public record, that goes to authentication, but how is it, what's the exception to the hearsay rule? Are you offering this for the truth?
I'm offering it not for the truth of what she said, but simply that she said it.
Okay.
And it's a public record. Yeah.
I'm going to sustain the foundation and hearsay objections at this point because we have two levels of hearsay. We have the document itself is hearsay, and then the statements that she made within it, those wouldn't be hearsay. Those are statements by a party opponent. But the document itself appears to be hearsay at this point, unless you establish an exception to the hearsay rule.
Yeah, I'm fine right now.
Okay.
Thank you. Let's look at Exhibit 46. Exhibit 46 is a email. Scroll that down a little bit so I can see the date, Jim. The other way. The other way. Thank you. Is a January 13th, 2026 email from you to Mr. Weiss. Do you see that?
Yes,
Did you send this to Mr. Weiss on that date?
yes.
Move to admit plaintiff's exhibit 46.
Any objection?
No objection, Your Honor.
Plaintiff's 46 is received.
You state in plaintiff's exhibit 46, I had authorized access to Ms. Wilder's email accounts during the marriage and while serving as the director of tasks. Is that true?
Yes.
Is that yes?
Yes, and it was just some of the accounts. It wasn't all of them.
Ma'am, I don't see anywhere in this document where you say plaintiff's exhibit 46, where you say it was just some of her accounts. Do you see that in there?
No, but I didn't say anywhere that it was all of them either.
Is there a reason you didn't state that in this document? That there
No.
were other accounts that you didn't have access?
No?
Let's go to exhibit 47. Plaintiff's exhibit 47 is a February 18th, 2026 email from you to Mr. Weiss, correct?
Yes.
And you sent this on that date?
Yes.
Last paragraph says, given your client's current litigation posture and the expanding scope of financial and tax-related scrutiny, I strongly recommend that you advise your client to give serious consideration to settlement. You wrote that, correct?
Yes.
And what were you seeking in settlement at that time?
To fix all the back taxes on all of the businesses.
Nothing else?
Oh, I was also, I don't know the exact, I sent over a lot of settlement agreements, but all of them had fixing the back taxes and fixing all of the stuff with the accounts.
So you weren't conditioning anything on settlement in terms of your tasks board directorship that you allege or money from past? You never saw the settlement of that?
I can't say never, but I can't say it was on a settlement that's being outlined in this one. I don't
Well,
remember.
Mr. Weiss was representing Christine Wilder in the divorce case, right?
Yes,
And you were trying to settle that case, right?
I was.
And you wanted money from that case, did you not?
I think I did ask for some funds in to pay for back bills in my settlements, but I don't remember asking in this specific time frame.
No, I'm just talking about in the divorce case. You're seeking in this exhibit a settlement that was a settlement of your divorce case, was it not?
This was, yeah.
Objection asked and answered.
Overruled.
And in your divorce case, you were seeking a lot of money from Miss Wilder, were you not?
No, not a lot of money.
Well, what were you seeking in money?
I believe initially I was only asking for like either 25 or 30,000 to pay back bills.
Well, you're also asking for half of the ownership of the TAB entity, Tax Accounting and Bookkeeping, are you not?
Objection.
What's the
Foundation.
objection? Overruled.
Yes,
Right. And that's very valuable, you believe, correct?
the income that went to it for TAS is valuable, yes, for the directors.
And it would be valuable to you if you could leverage a settlement in the divorce case, correct?
I mean, can you say that question again?
Yeah, you were asking in this document, Plaintiff's Exhibit 47, for a settlement of the divorce case, which would result in money going to you, would it not?
Yes,
Okay. And you're saying that given the client's, given Christine Wilder's current litigation posture and expanding scope of financial and tax-related scrutiny, you were causing financial and tax-related scrutiny, correct?
no,
You're saying you weren't making complaints we just talked about, well, who was scrutinizing, if not you pursuant to your complaints?
the complaints would cause scrutiny. So yes, I was, if you want to say that my complaints would cause it, but the actions themselves should cause scrutiny.
And then let's move to the next document, which is Exhibit 63. Is that an email that Plaintiff's Exhibit 63, is that an email that you sent to Mr. Weiss on March 24, 2026?
Yes,
And you said, I have prepared 4 follow-up complaints for agencies that have requested additional information. Who were those agencies?
I don't remember at that time. Probably the IRS and maybe others, but I don't remember who else off the top of my head.
And at the end of the document, you say, I remain open to working towards an amicable resolution and exploring whether reconciliation is possible if your client is willing to engage in good faith, correct?
Yes.
That's engage in good faith settlement?
Yeah, fixing the entities. Yeah, fixing the back taxes in
Well-
good faith, engaging in making things right.
Well, not only that, but settling your divorce case and getting money, correct?
Objection.
That in this, I don't see that in
Argumentative.
this.
Well,
Overruled.
Mr. Weiss he's Christine Wilder's divorce lawyer, correct? And you're negotiating with him a settlement, correct?
I am, but I don't know if this is an email about, let's see. I mean, you can work through the taxes without settling. So, I mean, this just says I want to engage in good faith.
Okay.
And coming up with a resolution could be either in the divorce or fixing the businesses.
So then you say in the second paragraph of that exhibit, the matters raised in those submissions are issues your client and I are capable of addressing directly and resolving in a coordinated manner without agency involvement, which is my preference. provided the IAWH is lifted and we're able to begin working together. So you were conditioning the lifting of the IAWH, correct? On what you wanted.
Yes,
And what's the IAWH?
it's the injunction against workplace harassment.
That was entered against you and you wanted it lifted in exchange for stopping what you were doing, correct?
Yes,
That injunction remains in place, correct?
correct.
There's another order of protection in place, correct?
No,
You don't remember an order of protection against you?
there's only an injunction against workplace harassment.
Let's go to Exhibit 78. Oh, move to admit plaintiff's Exhibit 47, Your Honor.
Any objection to plaintiff's 47?
Your Honor, we have an objection that this is Rule 408 evidence.
Next one.
The objection's overruled.
Okay.
That objection's untimely. All the all the testimony came in on the settlement negotiations without objection. So I'm going to receive into evidence plaintiff's 47. What about plaintiff 63?
Move to admit, Your Honor.
Any objection?
No, Your Honor. Oh, it's same objection 408, but I understand you're overruling it.
Plaintiff 63 is received. The objection's overruled.
Let's go to Exhibit 78, please. You stated that you're only aware of a injunction against workplace harassment against you, correct?
Correct.
No other order against you, correct?
Not that I'm aware of.
Exhibit 78 is an order of protection. Do you see that? Are you alleging that you were never served with this?
There's nothing.
I don't either.
Oh.
And we don't either.
I'm sorry, it's 70.
78. Thanks, Jim.
There we go. Sorry.
You've never seen Exhibit 78, ma'am, which is an order of protection?
I
the-
have, I'm sorry.
Go ahead. That was my bad.
There was a petition, but I don't know. All I'm aware of is the injunction against workplace harassment actually being signed off by the judge.
That's not my question, ma'am. Are you alleging that you've never seen Exhibit 78, which is an order of protection entered by the Yavapai County Superior Court against you?
Objection misstates the document.
That's not what this is.
Well, how so?
It's not signed, Your Honor.
Can you scroll down?
So I'm missing it.
Is this an actual entered order?
It is an order. I'll avow it's an entered order.
It's not signed, Your Honor, on the second page.
There is an order. I'll make an avowal, Your Honor. There is an order of protection against her. There's been discussion in the family law case about her wanting to have a hearing on it.
Objection, Your Honor.
Well, I don't see anything on here that shows it was filed with the court. Can you scroll up to the top page? I see a case number. Now, I know how these get entered. It's an electronic system, and I see down there where it has a /S/ or yeah, the /S/. I saw that. It has the judge's name printed to the right of that. So I don't know whether this was actually entered or not. How can we clear that up? And I'm not just going to take an avowal of counsel because you're asking me to introduce this into evidence. I need
Judge.
more than an avowal.
Judge, I understand. I'm going to ask my office if we can obtain the affidavit of service
Okay.
with regard to that.
And I'll also get online at lunch, Your Honor. And if need be, contact Yavapai County Court. So
I'll reserve ruling on plaintiff 78.
Of course, and Your Honor, our position is that's just not this document. If we get it, okay, but I want to hear this testimony too on the document.
Okay, so regardless of what we're going to do afterwards, is it your testimony that you've never seen Exhibit 78 ever?
No, I've seen it. I just know it didn't go through the court and actually get awarded
How did you see it?
because it was served to me.
Okay, this was served on you by who?
A process server when I was walking into court one day.
Okay. And have you abided by this order of protection?
This is not anything this is not a valid order of protection.
Have you possessed, received, or purchased firearms since the date on this order?
This order,
Objection misstates the document.
The objection's overruled.
this order has August 29th, 2025. I wasn't served until a couple, 6 months after that. So, no, I didn't adhere to any rules in this order of protection because I wasn't served it at the time that she filed it.
Okay, after you were served with this document, have you possessed, received, or purchased firearms?
No, I surrendered my firearms immediately
Why?
because that's what you're supposed to do when you get one of these documents.
And you had a hearing, did you not? Before a judge up in Yavapai County about the order of protection, correct?
I believe the hearing was the injunction against workplace harassment.
So you don't believe you had a hearing on protection?
I believe that it was part of it, but I don't believe it was issued. I think that's why she only issued the injunction.
Just my question is, you don't remember a hearing on an order of protection against you? It's a yes or no.
I think they were coupled together.
Okay, you think when you say they, an order of protection and an injunction against harassment, correct?
Correct.
And then are you saying only one was entered but not both?
No, I have a hard time remembering the exact details of this specific thing because there were two things. But I believe that the court said that she needed to file it in a different court or that it wasn't something they were going to be reviewing at that time. It was part of the hearing, but I don't remember it going through to the end.
So you don't even remember losing any order of protection hearing, correct?
Not an order of
Objection.
protection, only injunction against
Foundation.
workplace harassment.
Okay, hold on. I need to pause for a moment. Do two things when you make an objection. Please stand
Yes, Your Honor.
so that you can be properly recognized. And don't wait for me to ask what the basis is. State the basis of your objection. And when your counsel makes an objection, you need to stop testifying so that he can assert the objection on your behalf and I can rule, okay?
Yes, sir.
Thank you, Your Honor. Your Honor, I'd like to make an objection for first foundation, but also for relevance. I don't understand where we're going. It looks like we're putting on things with the divorce case rather than the question as to why we're here.
Okay, the objections to foundation and relevance are overruled. Go ahead and proceed.
Let's go to Exhibit 32, Plaintiff's Exhibit 32. Gosh darn. Is that an email that you wrote to Mr. Weiss on April 13, 2026?
Yes.
Objection, Your Honor, foundation or not foundation, I'm sorry, Rule 408 evidence.
Okay, it hasn't been offered yet. Right now, he's laying the foundation for it. So when he offers it, you can assert your objection.
Thank you, Your Honor.
On the fourth paragraph of Plaintiff's Exhibit 32, it states, as reflected in the Arizona
Okay,
Department.
hold on. Because there's going to be an objection to this, it's not appropriate to start quoting from the evidence before it's received into evidence. So lay the foundation that you want and then offer it into evidence and I'll hear any objections.
Okay, thank you, Your Honor. So you sent this Exhibit 32 to Mr. Weiss on April 13th, 2026, correct?
Yes.
Your Honor, I move to admit it because when you look at it, there's a reference to Rule 408, but there's no settlement offer in there. And then secondly, I'm only offering it for the purpose of the statement made in the fourth paragraph, which has nothing to do with settlement.
Okay, so plaintiff's 32 is offered. Is there any objection?
No, Your Honor.
Okay, plaintiff's 32 is received.
Thank you. In the fourth paragraph of Plaintiff's Exhibit 32, it says, as reflected in the Arizona Department of Health Service record, I remain listed as a principal officer board member on the task license, maintain active portal access. Was that a true statement when you made it?
Yes.
And you still maintain full portal access to the Arizona Department of Health Services portal, correct?
To my specific portal, yes.
And that portal is as a director of task, correct?
Correct.
Go to Exhibit 57. You see this email I sent to Mr. Meyer on June 24th, 2026?
Yes.
Did Mr. Meyer provide that to you?
I believe I saw this for the first time last night.
So you're saying Mr. Meyer did, what is it, then 6? So 35 days after Mr. Meyer received it from me, you're saying you saw it for the first time?
No. The email itself, I don't know if I've honestly seen this email. I think I just saw the actual documents.
You saw the documents that were attached to the email, but not the email? Is that your testimony?
Correct.
So, and the documents attached to the email were the completed 2026 task application for renewal, correct?
Correct.
Move to admit, Your Honor.
Plaintiff's 57, any objection?
Your Honor, I do object because the attachments to this PDF are not included as part of the exhibit. And so we don't know what the actual attachments are.
So what's the legal basis for the objection?
It's not the best evidence, and there's not foundation for the email coming in. The witness testified that they had seen the attachments, but not this email. So I don't know if there's foundation for this email.
Is anybody going to be offering the actual attachments?
Yes, Your Honor.
Okay, why don't we get to that? She testified she doesn't think she saw this email, so I will sustain the objection to plaintiff's 57 at this point, and why don't you go directly to what's attached?
go to Exhibit 34. Plaintiff's Exhibit 34, please. Jim,
I'm sorry. 34?
please.
I got the affidavit of service. I apologize.
I said 34. Thank you, Jim. Okay. Exhibit 34. Is a number of pages that starts with marijuana dual renewal application. Do you see that?
Yes.
And do you see page after page of a completed application?
Mr. Weiss, can you scroll down so the witness can see it?
Your Honor. Art, do you know which page of the document?
Your Honor, and I apologize, I'm still a bit of a caveman when it comes to papers and electronics. It might be easier for the witness to look at the pages rather than scrolling, but I defer to the court.
Well, we essentially operate paperless. If you want to, I mean, this is going to be the official exhibit, but if you have one that you want to show her in paper form, I'll let you approach the witness.
Yep, okay, thank you, Your Honor. May I approach you?
Of course.
34, correct, Jim?
Correct.
A plaintiff's exhibit 34 is a completed 2026 renewal application. Do you see that?
Yes.
Okay, and does this refresh your recollection as to the attachments in my email to your attorney that you reviewed?
Yes.
And did you review those on or about June 24th?
I don't know if it was that exact day, but it's sometime between then and today. Yeah.
Number on the exhibit, Jim?
34.
Move to admit plaintiff's exhibit 34.
Any objection? Pardon me?
Sorry, Your Honor. No objection, Your Honor.
Plaintiff's 34 is received. You may.
Thank you. Let's go to exhibit 62. Plaintiff's exhibit 62 is a July 6, 2026 email I sent to your attorney. Do you see that?
I do.
Did your attorney share this email with you on or about July 6, 2026?
Can you scroll down so I can see the rest of it? Yes, I believe I've seen this email.
When did you see it?
I don't know the exact date.
Was it in early July 2026?
Yeah, I think it was not too long after this email came over, I'm sure.
Move to admit plaintiff's exhibit 62.
Any objection?
No, Your Honor.
Plaintiff 62 is received.
Now, there are attachments to plaintiff's exhibit 62, and I want to talk about those attachments right now. Let's refer to exhibits 27 first of all, and then we'll go to 28 after that. Do you recall getting this attestation that I requested or TAS, I've requested on TAS's behalf that you sign to renew the license.
Yes,
And you would have received that in early July of 2026, correct?
I believe so. Yes,
And you have not signed it, correct?
correct.
Okay. And are the, in exhibit, first of all, move to admit plaintiff's exhibit 27?
Any objection?
No, Your Honor.
Plaintiff's 27 is received.
Okay. Quickly, is it true that you don't have an excluded felony offense to your knowledge?
Correct.
You don't have a direct or indirect familiar or financial relationship with a marijuana testing facility or a laboratory with a laboratory registration certificate under 9 AAC 17.
Correct.
You've not had an ownership interest in a marijuana business license in Arizona or any other state that had the license to operate the marijuana business revoked.
Correct.
This attestation is authorized by the marijuana establishment,
Yes.
and the information provided to the department is true and correct in the application that you had reviewed, correct?
The application asks for a sign off on the financials. And so that's why I wasn't sure, like, I really don't know. I can't,
Where in the application does it say there's a sign off on the financials?
it was in the binder that you brought over here. It had, there was a checkbox that you got to say that that it's operating as a not-for-profit. So that's essentially knowing that the financials are good.
And that's the attestation you signed in 2024, the task was operating as not, let's go to the 2020. Oh, by the way, let's go to exhibit 20, on exhibit 27, just for the court's clarity, that the box is checked, renew dispensary registration certificate, correct?
Yes.
Okay, so I apologize. Did I move to admit exhibit 27?
Plaintiff's 27 already was received.
Okay, my bad.
And no objection.
Please go to 28. And I believe plaintiff's exhibit 28 is the exact same attestation, but if you scroll down, there's a checkbox next to renew establishment license, correct?
Yes.
Move to admit exhibit 28, plaintiff's exhibit 28.
Any objection?
Hold on one second, Your Honor. I apologize. No objection, Your Honor.
Let's go
Plaintiff's
to,
28 is received.
excuse me, I apologize. Let's go to plaintiff's exhibit 29. Plaintiff's exhibit 29 is an attestation that you signed on May 13th of 2024, correct?
Yes.
And in it, you said, I'm a principal officer or board member for the medical marijuana dispensary listed on this renewal application, and the dispensary is still operating on a not-for-profit basis, correct?
Correct.
And to your knowledge, YCC was operating the TAS dispensary on a nonprofit basis at that time?
Correct.
Move to admit plaintiff's exhibit 29.
No objection, Your Honor.
Plaintiff's 29 is received.
Let's go to exhibit 33. That's an email from Alan Bostock of Mr. Weiss's firm dated June 9, 2026 to your counsel. Do you see that?
Yes.
Did Mr. Meyer provide that to you on or about June 9, 2026?
I can't say for sure if he if he gave me a copy of it to see, or if he talked to me about it, but I remember the details of this email, but I don't remember reading the email specifically.
You don't know one way or the other whether he gave it to you?
He may have.
Objection asked and answered.
That objection's overruled.
Sorry. And Your Honor, I'd just like to say I said geez just now, and that was because I almost tripped.
Okay.
Ma'am? Do you know whether you've seen this document before?
I said, I
today?
don't know.
Your Honor, I apologize. Have we admitted Exhibit 39, Plaintiff's Exhibit 39?
No,
So let's
No.
go to, I apologize to counsel and Your Honor. Let's go to Exhibit 39, please. Plaintiff's Exhibit. Is that an email that you sent to Mr. Weiss on on April 24, 2026?
Yes.
Keep scrolling down, please, Jim. Okay, so at the end of Exhibit 39, you state my prior settlement.
Why don't you offer it
Oh,
before
yeah.
you read?
Yeah, move to admit, Your Honor.
Any objection to plaintiff's 39?
No, Your Honor, no objection.
Plaintiff's 39 is received.
And you state in your email to Mr. Weiss, my prior settlement position has been intended to resolve these issues in a more efficient and structured manner without third-party regulatory and governance involvement. I remain open to a resolution on that basis. So you remained open to a resolution of your divorce court case. And you indicated you wouldn't continue regulatory and governance involvement if there was a resolution, correct?
I think that would fix a lot of things. Yes.
Let's go to Exhibit 52. This is scroll back up to the top, please. This is a social media post dated July 9, 2026. Are you familiar with that?
No.
Okay, scroll down, Jim. It says, Brandi and Wilder, nothing says winning quite like making sure absolutely nobody wins. A truly fascinating commitment to the plot. You didn't write that?
Oh, I wrote that.
Move to admit Plaintiff's Exhibit 52.
Any objection?
Yes, Your Honor, Foundation, is this part of her own Facebook account or what is this? Where's it pulled from? I am a little confused, and so I would say Foundation.
She admitted writing it. You can, if you want
Okay.
to know all that, you can talk to her about it. When you examine her, the objections overruled, plaintiff's 52 is received.
And Your Honor, just for the record, this is another exhibit we received late last night.
Let's go to Exhibit 55. Exhibit 55 is an email thread between me and Mr. Meyer. And at the top, he gives me a list of financial information he alleges you need to sign the attestation. Have you seen this email from Mr. Meyer to me?
Yes.
Okay, let's scroll down so we capture the previous emails, please. Okay, scroll down one more. Actually, go to the bottom, Jim, first. I apologize. It might be more logical. And then work your way up.
Am I able to
Okay.
take a bathroom break soon?
We can do that. In the interest of time, I wasn't going to necessarily take a break, but why don't we do that? We've been going for a little while. We're going to take the noon recess at noon. So we'll take about as soon as everybody's ready, we'll start back up. So 5 to 10 minutes.
Thank you, Your Honor.
Thank you, Your Honor.
CV2026-020553, Total Accountability Systems versus Ehnes-Wilder. The record will show the same appearances that we had prior to the recess. We have Ms. Ehnes-Wilder back on the stand. You may resume your examination, Mr. Bork.
Yes, we were looking at the bottom of Exhibit 55. I don't think that plaintiff's Exhibit 55, and that was not admitted yet. So I'd like to pick back up there.
And you're offering it at this point?
Not quite yet. I just wanted her to look at it, the entire thing first, Your Honor. And
Okay.
thank you. So if you could scroll to that date, this is nope. Yeah, just the first email at the bottom. I apologize, Jim. I usually control these things and I should be. So if you can go to that first email that I sent him at the bottom of Exhibit 55. Yep, that's it. Okay. And then the date. Okay. You see that on plaintiff's Exhibit 55, the bottomest email is my email to Mr. Meyer on June 16, 2026. You see that?
Yes.
Did Mr. Meyer provide that to you on or about that date?
Yes.
Okay, scroll up, Jim, to the next email, please. June 22nd, 2026, I emailed your counsel. You indicated to me last week you would identify the precise financial data and structure your client relied on in 2024 when she attested that TAS was operating on a nonprofit. You have not done so. Please do so by Wednesday at 5 p.m. or TAS will assume your client is unwilling to do so. And then in the next paragraph, I said, in addition, TAS offers the following to resolve the license renewal issue. If your client, typo, signs the attestation, TAS agrees that it will not use her signing as evidence that she approves of the TAS financial structure. In other words, TAS will not use her signing in this or any other litigation as evidence of an admission. And then TAS's license continues to be jeopardized by your client's failure to sign the attestation. Did Mr. Meyer send this email to you on or about June 22nd, 2026?
I don't know if it was the exact date, but I have seen this email.
Okay, go up to the next email in the thread. No, right there, yeah. June 22nd, Mr. Meyer writes back, Art, I'm in the middle of prepping for a trial. I propose numerous ways to get this done. Do you see that email?
Yes.
And there's no answer to my question, correct, as to what you relied on in 2024?
Correct.
Okay, scroll up, please, Jim. Next email. June 22nd, 2026, from me to your counsel. You've ignored two simple questions. Will you identify the precise financial data and structure your client relied on in 2024 when she attested that TAS was operating as a nonprofit? You told me last week you would. Will your client sign the attestation knowing it will not be used by TAS as evidence or an admission she agrees with the TAS financial structure? Did Mr. Meyer send this to you on or about June 22nd, 2026?
Again, I don't know the exact date I got it, but I have seen this email.
And you've read it?
Yes.
You understood that TAS wasn't going to use your signing the attestation against you as any kind of admission, correct?
Right, but TAS isn't the authority who could get me.
No, that was just my question to you. You understood that TAS was representing to you that if you signed the attestation, it was not going to use it as any kind of admission by you, correct?
Correct, but.
Okay, no, that's fine. Let's scroll up. And then I followed up with your counsel on June 23rd, 2026, because again, during this period, by the way, we're burning daylight, right? The TAS license is getting near the expiration on August 7th, 2026. You knew this at the time, correct?
Objection, that misrepresents counsel and plaintiff's own statements to this court in its motion in early June that they had enough time.
Rephrase your question.
Yeah, you understood in this time frame in June of 2026 that TAS's license would expire on August 7th, 2026, if not renewed.
Objection, foundation.
Overruled. She can say whether she knows that or not.
Yes.
Okay, scroll up, please, Jim. Then Mr. Meyer writes back to me on June 23rd, Art, I'm getting that information. Did you get that from Mr. Meyer? Did he send that email to you?
I don't know if I saw that email, but it might have been in one of the strings that he sent me.
And then the next email is Mr. Meyer says, here's a list of information that is needed to sign the attestation. Do you see that? That's June 24th.
Yes,
And you've seen that before, correct?
yes.
Plaintiff moves to admit plaintiff's exhibit 55.
Any objection?
No objection, Your Honor.
Plaintiff's 55 is received.
Okay, let's go to exhibit 30. Please. Plaintiff's exhibit 30. Plaintiff's exhibit 30 is a May 13th, 2026 email from a gentleman at the azdhs.gov, Jason Swank, to an email address canyon27b@gmail.com. Is that your email?
Yes,
Did you receive this email from Mr. Swank on May 13, 2026?
yes.
Move to admit plaintiff's exhibit 30.
No objection, Your Honor.
Plaintiff's 30 is received.
And in Mr. Swank's email, which is plaintiff's exhibit 30, it says in the second sentence, the Bureau cannot update its record without all POBMs submitting an attestation. The deficiency can be remedied if TAS were to submit an attestation from you. You see that?
Yes,
So you understood from the Department of Health Services that the deficiency in TAS's renewal application could, quote, be remedied if TAS were to submit an attestation from you, correct?
yes, that's what I've been saying since January.
Move on. Yeah, heat of the battle. Did I move to admit plaintiff's 30?
I believe so.
Okay.
Let me just-
No objection if.
I'll
Plaintiff's 30 is already in.
Okay, thanks. You actually brought a lawsuit against TAS in 2025, did you not?
I did try to.
What do you mean tried to?
It was never served on TAS.
Well, you filed a complaint, did you not?
I did.
Okay, and you made basically the same allegations you've made in this case, correct? It was a wrongful removal of you as a TAS director. Christine Wilder breached her fiduciary duties and similar allegations, correct?
Correct.
Let's go to exhibit 35. Exhibit 35 is a minute entry order by the Maricopa County Superior Court. Go to the bottom of it, please. It's dated January 20th, 2026. And it said, at the bottom, it says, it is ordered dismissing this case in its entirety for lack of service and lack of prosecution. Did you receive this minute entry order on or about the 20th, January 20th, 2026, when it was entered?
Yes,
And you understood that the case it had been dismissed in its entirety for lack of service and lack of prosecution, correct?
correct.
Move to admit exhibit 35, Your Honor.
No objection, Your Honor.
Plaintiff's 35 is received.
Go to exhibit 43. I don't believe that's in evidence. Exhibit 43 is a June 11, 2026 email from me to your attorney. Do you see that?
Yes,
And then I indicated in the third paragraph that your belief that somehow your client lacks access to the department's portal or TAS's renewal application is erroneous. Are you aware that your counsel was taking the position that you didn't have access to the department's portal?
Objection. Misstates statements and hearsay.
Overruled. You can answer the question.
I'm trying to read the exact words that he stated here.
My question is, are you aware that your legal counsel has taken a position, regardless of what that document says, that your legal counsel's taken a position that you lack access to the department's portal?
I would have to first read that.
Ma'am,
Hold on
you're-
one moment,
I'm sorry.
Mr. Meyer.
Sorry, same objection, hearsay. I don't know where this position that he's saying we've taken is.
The objection's overruled.
Ma'am, my question, are you aware that your counsel has indicated to me in writing that you lacked access to the department's portal?
First, I'd have to read that. So if you want to give me a second to actually read that before you ask me to, I don't know.
You don't know
I,
whether,
I want to read the email to see what it says.
no, that's my letter. I'm just asking you a question irrespective of the letter. Like if you can, not the letter. I'm asking you, do you have any knowledge that your counsel has told me that you lack access to the department's portal?
I don't know if it was to the department's portal because that's not what I had conveyed.
So you don't know?
I don't know.
In any event, you admitted previously you had access to the department's portal the entire time, and you still have access to the department's portal, correct?
That's why I believe it's a misunderstanding.
But answering my question, you had access to the department's portal throughout, and you still have access to the department's portal, correct?
Correct.
And you have great familiarity and expertise in working in the department's portal because you've worked within it for years, have you not?
I mean, for the few things that I do in there, yeah.
You don't have any problem getting onto the portal and looking around?
No.
Move to admit plaintiff's exhibit 43, Your Honor.
Any objection?
Your Honor, if it's offered for the truth, I think it's hearsay in the sense that it says I've said something or represented something. So yes, I object to hearsay and foundation.
What is the purpose? What is it being offered for?
It's being offered for a notice of that she maintains active portal access and any.
She's testified
Yeah, she's
to that.
testified that.
This
In
is
addition,
hearsay.
it's another, if we scroll down, it's another request that she sign the attestation. So TAS through me is making a request that she sign. And again, the issue before the court in the motion is whether this alleged director is jeopardizing the TAS license. She's being put on notice that she has everything she needs to do. And you can see it in bold. Please confirm she will sign the renewal attestation.
Okay, the hearsay objection is sustained to the extent it's offered as an additional request that she sign the attestation. It's cumulative. I can see in the evidence that she's been repeatedly requested to sign it. So I'm going to sustain the objection to
And-
plaintiff's 43.
And Your Honor, we would allow the admission of it if they're able to show what these statements are, where they're made, or that type of evidence. And also I'd like to say that if they want Ms. Ehnes-Wilder to log on to her portal access right now and show that, we can just get the truth and we don't have to go through this dog and pony show of hearsay.
Okay, ask your next question.
Yeah. Go to plaintiff's exhibit 59. We've already gone through that, so we don't need to do that again. Let's go to exhibit 61, please. That's a marijuana dual renewal application 26126. Your application's been received, and if you scroll down in this document, correct the items, and then it says attestation. The attestation provided, excuse me, Jim, provided to the department to renew, it was not signed and or dated by each principal officer and or board member. Did you receive a copy of this notice?
I don't think I have received a copy of this notice. I think I have seen it in the portal, but I don't think I've received a copy of it.
You've seen it in the portal?
Yes.
Okay, move to admit exhibit 61.
Any objection?
No, Your Honor.
Plaintiff 61 is received.
No further questions.
Hey, any cross-examination?
Good morning still. Can I call you Brandi? Okay, thank you. Brandi, what's going on here? Why are you not signing the attestation?
Because I don't have access to verifying that nothing has changed since 2024 because I don't have any way of seeing. I mean, you can't just say, yes, I believe that that they're just doing everything right just because they're a dispensary or just because someone has a contract or something like that. Like, the fact that the 1099s for TAS's income going to the directors was going to TAS accounting and bookkeeping and then got switched to KWLH in 2024 means there was a significant change, but there's no contractual change. There's no anything. So I don't know why that money is going there instead of going to TAS. I mean, there's just big discrepancies.
And so in 2024, in 2024, you did sign the renewal attestation. Is that correct?
Yes.
Okay. And at that time, did you have the knowledge to be able to make that attestation?
Yes.
And what was that knowledge?
We had access to any of the sales or anything that was going on at the dispensary at that time. And also all of the bank accounts that were associated with TAS.
In 2024, had you been removed as a director when you made that attestation of TAS?
No.
Okay. And so you had access to the company's financials.
I did.
You knew, or were you involved in the running of TAS as a business?
TAS, the business side of it where the directors were, yes. So anything that had to do with compliance things or, doing applications online or things like that and making sure that the dispensary is doing everything they're supposed to do. And that side of TAS, yes, but I was not involved in the day-to-day operation inside the dispensary, but I did have access to any of the sales and stuff that was coming over via email or any discussions. I was privy to discussions that were going on with regard to that. I just had a general knowledge that things were being done properly.
Okay. And as directors, how much were in 2024 when you made that attestation as directors? How much were you and Miss Wilder making per month?
TAS was receiving $222,000 a month.
And who was TAS receiving that from?
Technically, Yavapai Cash and Carry, but it was actually coming over from one of their sub companies called SSW Investments, which is another reason that I wanted to see and verify what was happening with all the financials because the contracts with YCC, but SSW Investments is paying. So you'd have to see where SSW Investments comes in, how they are a player in what's going on. So.
Okay, so this is from 2024 and you knew this financial information.
Yes.
Okay. And of that 200,000+ a month, was that essentially just profit for you and Miss Wilder?
That was a license use fee or consulting fee that was for the directors after all TAS's initial bills were paid. So when TAS had legal or TAS needed to pay rent on a property or something, all those bills were all paid first, and then the rest was left for the directors.
Okay, and so it's not profit because it's a nonprofit, but it was paid to the directors.
Correct.
Okay. I'm going to pull up Exhibit 34, which is the dual renewal application, Plaintiff's Exhibit 34, which you looked at. And previously you indicated that there was a financial aspect of this. Can you talk about that and we'll pull it up?
Yes, I don't know what page it was on, but it's where you have to attest that the dispensary is still, or the license is still operating as a not-for-profit. So the only way to do that is to actually be able to verify that.
Okay, and so, and we're gonna pull up the language. But I wanna understand that, so in the renewal attestation, you're required to attest that TAS is operating as a nonprofit.
Correct.
And what does that mean to you?
That they are filing everything properly and that they are actually handling all of the money the way a nonprofit should.
And what are you lacking right now to make that attestation?
Anything. I don't have anything. So if I had anything, I could possibly say I could verify something.
And you see in this exhibit a lot of names. Are those the employees? Like here, I think this is okay. And so this is this the portion you're discussing, and page number this is? I apologize. But are you able to read that where it says important information for dual licensees?
Yes, and that's where it says I am a dual licensee and my dispensary is still operating on a not-for-profit basis, and I will submit an attestation in lieu of a copy of the documents outlined above.
And so are you able to make that attestation right now?
No, because I would need those documents above to be able to sign off in lieu of having them, like in lieu of submitting them to the AZDHS themselves.
Have you been provided, as Ms. Wilder or TAS or any of their counsels provided you those financial documents where you can make this attestation?
No.
Have you received a statement of TAS's CPA that it's operating on a not-for-profit basis?
The thing that they put up, I forget what the exhibit
Well,
was.
that's YCC's CPA, isn't it?
So that's the only part that I know, is that YCC is operating that way under our license, but I don't know that the money that's going to TAS is being operated that way.
Right. And so my question again is, have you received an attestation from a TAS CPA that it's operating as a nonprofit?
No.
Okay. And since February 2025, has Ms. Wilder allowed you to be involved in TAS the way that you were previously?
No.
Do you currently, since February 2025, have you had access to TAS's books and records?
No.
Have you had access to the day-to-day operations of TAS?
No.
Okay. Have you asked Ms. Wilder or her counsels for this financial information?
Yes, I sent a lot of requests, mostly to David Weatherwax, because I thought he was the counsel for TAS.
Okay.
And he was responding to me, saying that I'm just not a director, so I'm not entitled to that information.
Okay. And so, when did Mr. Weatherwax get involved with TAS?
When did he get involved with TAS?
Mm-hmm.
I believe it was in the beginning of 2024, but I'm not positive.
Okay. Were you involved with Mr. Weatherwax and his representation of TAS?
Not really.
Okay.
Let me make a disclosure. I didn't know that Mr. Weatherwax was involved in this case at all. He's my former law partner who I work closely with. I'm still social friends with Mr. Weatherwax. So I don't know what involvement he has. I did not know that he was representing TAS at all. So if anybody thinks that that creates an issue, please let me know that. You can talk about that over the noon recess.
Okay. We'll talk about that over the noon recess. Thank you, Your Honor.
Go ahead.
And I guess on the attestation related to this application, let's talk about the portal real quick. You have access to the Department of Health's portal, right?
I do.
And that's one of the ways, really the primary way, that applicants or licensees submit documentation to the Department of Health. Is that correct?
Correct.
Okay. And have you tried to access this application on the portal?
Yes.
And what happens when you try to click that application?
A little red bar comes up on the top and says that I did not start the application, so I cannot view it or complete it.
And have you told that to Ms. Wilder and her counsels?
Yes.
Have they responded to that?
Not that I'm aware of.
Does their response essentially that you are aware of say you're wrong and you do have access to it?
Yes, absolutely. It's just, you have access to the portal. You should be able to assign. I mean, that's the only response we've really gotten.
Okay. And so, and if we pulled up your portal access here, what would we see?
You go click on the application and it just literally says that you don't have access to it.
Okay. And you don't have access because somebody else submitted the application.
Correct. The only thing you can see, I think, is the deficiencies or, any attached documents, or there's a couple things you can see, but you can't access the actual application itself.
Okay. And now that you've seen the application, do you have any other concerns other than the attestation on whether it's operating as a financial nonprofit?
The attestation and the financials is the only issue.
Okay. And so if you were able to receive the financials and provided, I think you've said you needed 14 days to review. Is that correct?
I preferred that, but I know that time is of the essence.
Okay. And so now that
We're right at noon. Let's go ahead and take our noon recess. We're going to come back at 1:30. So we'll be in recess until 1:30.
Thank you, Your Honor.